Hi, welcome to the Beyond the Fine Print workshop. I'm Renee Turner, the founder of Thoughtful Lawyering. I'm really excited to have you here. Today I'm going to teach you everything you need to know about attorney-client agreements and how to maximize your attorney's time and expertise while also saving money. First, I'll break down the key components of an attorney-client agreement. We'll discuss how these elements can impact your legal costs and expectations. Next, we'll dive deep into retainer fees. I'll explain how they're calculated, how they apply to your case, and what they typically cover. Then, I'll explain exactly how attorneys bill their time, with specific examples to help you estimate the cost of phone calls, emails, and meetings with your attorney. To help you save money, I'll share 10 insider strategies to lower your legal costs. To wrap up our discussion on retainer fees, we'll discuss when you might need to replenish your retainer fee and under what circumstances you can expect a refund. I'll also briefly cover fee disputes and how they're typically handled. We'll conclude today's workshop by discussing red flags to watch out for in attorney-client agreements, negotiation tactics, and essential tips to ensure you get the best deal possible. I can't wait to get started. Let's dive in. Today we're going to cover 4 subjects. First, scope of representation. Second, retainer fees and billing. Third, client rights and responsibilities. And fourth, fee disputes and arbitration. To start, you might hear attorney-client agreements referred to by different names. While there are 3 common names for attorney-client agreements, they are all essentially serve the same purpose, to outline the terms of the attorney-client relationship. A retainer agreement is the most common type, especially when a client pays a retainer fee upfront. This agreement typically details the scope of legal services, fees, expenses, and billing procedures. A fee agreement is a broader term that specifies the terms of payment, including hourly rates, flat fees, or contingency fees. Finally, an engagement letter is a formal letter that outlines the specific terms of the attorney-client relationship, such as the scope of work, deadlines, and fees. It's often used for more specialized or limited legal services. I want to talk briefly about the scope of legal representation, which is an important element of your attorney-client agreement. The scope of legal representation outlines the specific legal matters or tasks your attorney is authorized to handle on your behalf. It essentially defines the legal work your attorney will do for you. Every attorney-client agreement should clearly state the specific legal services covered by the agreement, whether it's an uncontested or contested divorce, custody or visitation matter, child support case, or other legal matter. This is important because if you ask your attorney to do something beyond what's outlined in your agreement, they could ask a judge to withdraw from your case. This means they would no longer be your attorney. They could use the agreement as proof that they didn't agree to that specific service. I once had a case where an attorney agreed to handle an uncontested divorce, which is usually less complex and less expensive. However, the divorce became contested when the spouses couldn't agree on a custody arrangement. The attorney used the attorney-client agreement as a reason to withdraw from the case, leaving their client to find a new attorney or represent themselves. Your attorney-client agreement should also clearly state when the representation ends, meaning when the attorney finishes the work they were hired to do. For example, if you hired an attorney for your divorce, the agreement should state that the attorney's representation ends when a judgment of divorce is signed by a judge and finalized by the court. Your attorney-client agreement should also clearly state what's not included in the representation. This might include things like appeals, financial advice, tax planning, estate planning, or post-judgment matters like contempt motions. A contempt motion is a legal request filed with a court to hold someone accountable for failing to comply with a court order. This can happen in various legal contexts, including divorce and family law cases. For example, if someone refuses to pay child support or violates a custody order, the other party can file a contempt motion. The court may then impose penalties, such as fines or jail time, to enforce compliance with the court order. Typically, the attorney who represented you during the initial divorce, child support, or custody proceeding won't continue to represent you if you need to file a contempt motion. You'll either need to enter into a new agreement with your original attorney, find a new attorney, or represent yourself. Next, let's discuss who at the law firm will represent you. Typically, when you sign an attorney-client agreement, you're hiring the entire law firm, not just one specific attorney. This means the firm can assign different attorneys or staff members to work on your case as needed. The attorney you meet with during the initial consultation might not be the one who works on your case all the time. Think of it like doctors. If you're ever admitted to the hospital, your doctor is not on call 24/7. Other doctors cover when your doctor isn't available. The same is true for lawyers. Other lawyers or staff within the firm may assist on your case as needed. Now let's talk about retainer fees. A retainer fee is an upfront payment made by a client to secure the services of a lawyer. It's like a deposit that reserves the lawyer's time and expertise for your case. This money is typically held in a trust account and is used to pay the lawyer's hourly fees and other costs associated with your case. For a family or divorce case, the average retainer fee is usually between $3,000 and $5,000. However, it could be much more depending on the complexity of your case and the attorney's experience. It's important to know that the retainer fee typically doesn't cover the total cost of your case. Think of it as a down payment. The initial retainer fee will likely cover the attorney's hourly rate for work on your case, as well as costs like court filing fees and process server fees. Attorneys generally charge an hourly rate for their services. That rate can vary depending on the attorney's experience, the complexity of the case, and the geographic location of the law firm. For example, an attorney in New York City will likely charge more per hour than an attorney in Buffalo, New York, because the cost of living in New York City is higher than in Buffalo. An attorney's hourly rate also depends on their level of experience. Law firms have a hierarchical structure, with named partners at the top, followed by partners, associates, and paralegals. In this chart, you'll see examples of different hourly rates for paralegals, associates, senior associates, partners, and named partners. Let me explain the experience levels of each. In my example, a paralegal may be billed at $250 per hour. It's important to note that while paralegals may be billed at an hourly rate of $250, their actual compensation, including salary and benefits, is often lower. The difference is typically used to cover the law firm's operational costs, which includes rent for office space, utilities, office supplies, and marketing costs. The cost to work with a paralegal is the lowest because a paralegal is a legal professional who works under the supervision of a lawyer. They are not lawyers themselves. They perform tasks that require knowledge of legal concepts, but don't require the full expertise of a lawyer. The tasks that a paralegal might perform include conducting legal research, drafting legal documents, or assisting with client communication. Next is an associate attorney, who may be billed at $450 per hour. An associate is typically an entry-level or mid-level attorney who is often closely supervised by senior associates and partners. They are typically responsible for conducting legal research, drafting documents, communicating with clients, managing cases, and preparing for hearings or trials when necessary. Moving up the ladder, we have senior associates, who may be billed at $500 per hour. Senior associates are typically seasoned attorneys with several years of experience. They often lead teams of more junior associates and paralegals by assigning them tasks and making sure everything gets done right. Next up are partners, who may be billed at $550 per hour. Partners typically have an ownership interest in the law firm. As part owners of the law firm, they're responsible for bringing in new clients. You might meet with a law firm partner during your initial consultation, but don't be surprised if the attorney who actually handles your case is a senior associate. The senior associate will oversee more junior associates who do the day-to-day work on your case. While a partner might not be involved in the nitty-gritty of your case, they may step in for important court appearances after being brought up to speed by their team. Finally, we have named partners, who may be billed at $625 per hour. A named partner is a senior partner in a law firm whose name is included in the firm's name. The hourly rate for a named partner is usually significantly higher because they have a proven track record of success, extensive experience, and a strong reputation in their field. Their involvement in a case can significantly impact its outcome. Usually, their high hourly rates reflect their value to clients and their ability to win tough cases. So, what exactly are you paying for when you hire an attorney? Let's break it down. You're essentially paying for their time. Every minute they spend on your case is billable. This includes meetings with you, discussions with the other side, discussion with the other side's attorney, and internal strategy sessions about your case. You'll also be billed for all communications, including emails, letters, phone calls, and even text messages, whether they're with you, the other side's lawyer, or other professionals involved in your case. Lawsuits often require drafting legal documents like a petition, complaint, answer, or counterclaim. These documents are called pleadings. Lawyers also draft motions, like a motion to dismiss or a motion for reconsideration. Keep in mind, legal documents can be time-consuming to prepare. You'll be billed for the time spent researching the law, developing arguments specific to your case, and drafting and filing these documents. Finally, most people expect to pay an attorney for court appearances. However, you're not just paying for the time the attorney spends in the courtroom. You're also paying for the hours spent preparing for that appearance, including reviewing documents, researching the law, and developing legal arguments. And don't forget about travel time to and from the courthouse, as well as the time spent waiting for your case to be called. So, a single court appearance can add up very quickly. This chart shows how lawyers bill clients in 6-minute increments or tenths of an hour. Every lawyer who bills hourly is required to track their time spent on various tasks related to a case, such as research, writing, phone calls, meetings, and court appearances. Many law firms use specialized timekeeping software to automate this process. So let's say you have a call with your lawyer. They'll often use a timer to keep track of how long they talk to you. Each 6 minutes of work is considered a tenth of an hour. The total time spent on a task is rounded up to the nearest 6-minute increment. For example, if a task takes 11 minutes, it's rounded up to 12 minutes, or 2/10 of an hour. The rounded time is then multiplied by the lawyer's hourly rate to calculate the billable amount. We'll walk through specific examples on the next few slides to ensure you fully understand this concept. Before we get to the examples, there are a couple things I want to stress. First, all attorney bills should clearly itemize the time spent on each task. This includes the name of the attorney or paralegal and a specific description of the work done, like research, drafting, or meeting with you, the client. Second, when you receive your monthly bill, I encourage you to review it carefully. If you have any questions or concerns, don't hesitate to reach out to your attorney or their administrative assistant. Discussing the bill shouldn't lead to additional charges. We'll discuss this more later. Let's walk through an example of how billing works for a 15-minute phone call. Imagine you have a 15-minute phone call with a partner at the law firm to discuss the status of your case. That partner charges $550 per hour. Now, remember that lawyers often bill in 6-minute increments. So, even though your call was only 15 minutes, it would be rounded up to the nearest 6-minute increment, which is 18 minutes or 3/10 of an hour. Given the partner's hourly rate of $550 and the fact that the call was rounded up to 18 minutes, the total charge for the call would be $165. To figure that out, you multiply 0.3, that's 3/10 of an hour, times 550, which equals 165. I've included additional phone call examples in your workbook. Please use those to practice figuring out the cost. Let's next talk about billing for correspondence, like emails, letters, and faxes. Law firms often charge a flat fee for each correspondence. This covers the time it takes to receive, review, and file the document. For example, a firm might charge a minimum of 3/10 of an hour, that's 0.3, for an email, even if it's short. That means even a short email could cost you a minimum of $135 based on a $450 per hour rate. Longer emails requiring more time to draft and respond would cost more. So, as you can see, you might think a quick email won't cost much, but it can really add up. I want to make sure you're aware of that. As we discussed earlier, lawyers often bill clients for the time spent traveling to and from the courthouse for hearings, trials, or other legal proceedings. Your attorney-client agreement should clearly outline how these travel fees will be calculated. This could be a flat fee, an hourly rate, or a combination of both. For instance, if a round trip to the courthouse takes between 13 and 18 minutes, the agreement might specify that you'll be billed for 3/10 of an hour, that's 0.3, or 18 minutes of travel time. If you have questions about charges related to travel to and from the courthouse, you should not hesitate to ask your attorney for clarification. Now that you know the ins and outs of attorney-client agreements and attorney fees, I'm excited to share 10 proven strategies to help lower your legal costs. First is to confirm court dates yourself. You might think it's easy to call your lawyer's office to check on your next court date, but it could cost you. Remember, attorneys bill by the minute. That quick 2 to 3 minute call could cost you $45 if your attorney's hourly rate is $450. To avoid that unnecessary legal fee, consider checking the court's online calendar using your case number or first and last name, or you can call the court clerk's office for free to verify the date and time of your next court appearance. By taking the initiative to confirm court dates yourself, you save your attorney the time and effort it would take to do so, which ultimately saves you money. Second is to keep and organize your documents. The moment you sign your retainer agreement, immediately send all relevant documents to your lawyer. Don't wait to be asked. As you receive new or updated documents, share them with your lawyer as soon as possible, even if you haven't been asked. By providing all necessary documents up front, you'll ensure your lawyer can work efficiently without any delays or interruptions. If they're missing something, it slows them down, and it will cost you money if they have to reach out to you to ask for that document. To make your lawyer's job even easier and save you even more money, organize your documents. Group, tab, or label your documents. The more organized your documents are, the faster your lawyer can work for you. Third is to request an agenda in advance of all meetings with your lawyer. A clear agenda helps keep the meeting focused on what matters, avoiding time-consuming tangents and unnecessary discussions. Knowing the topics to be discussed allows you to prepare questions, concerns, and potential solutions beforehand. If you need to bring any documents, you'll know ahead of time, eliminating the need for back and forth emails or phone calls. Remember, every time your lawyer reaches out, it costs you. An agenda also helps your lawyer prepare effectively, allowing them to maximize their time and make the most of the meeting. Being prepared enables you to make informed decisions during the meeting, reducing the need for follow-up calls and emails, which you now know can add up pretty quickly. Fourth is to prepare a list of questions for your lawyer before each call or meeting and email them beforehand. By emailing your questions in advance, you give your lawyer time to review and prepare thoughtful answers. This saves time during the call or meeting, ultimately reducing your fees. A well-organized list of questions also keeps the conversation on track. It prevents tangents and ensures that your most important concerns are addressed. Written questions can be more precise and easier to understand than spoken ones. This reduces the risk of misunderstandings and the need for back and forth discussions after the call or meeting, which can save you money. Fifth is keep your lawyer updated. It's a simple concept, but it can save you a lot of money. Imagine your lawyer spending countless hours drafting a document or preparing for a hearing, only to learn at the last minute an important detail you knew about weeks ago. Not only is this a waste of their time, but it can also hurt your case. To avoid unnecessary work and extra costs, share any new information, no matter how small, as soon as you know about it. Your lawyer should hear it from you first, not from the other side. This ensures they are always prepared and don't waste their time or your money on unnecessary work. Sixth is to use phone calls wisely. If you have a quick update or a simple question, consider sending an email instead of calling your lawyer. Lawyers often have busy schedules juggling multiple cases and deadlines. By emailing quick updates or simple questions, you're allowing them to address your concerns efficiently, saving them time and you money. Emails provide flexibility for both you and your lawyer. You can send updates at your convenience, and your lawyer can respond when they have time, rather than scheduling a phone call. A brief email takes less time for your lawyer to review and respond to than a phone call. Written communication often allows for more precise and detailed explanations. This can reduce misunderstandings and the need for follow-up calls. Emails also create a written record of your communication, which can be helpful for future reference. Seventh is to review legal documents, such as a settlement agreement, in advance of meeting with your lawyer. A common mistake many clients make is not reviewing documents before meetings. You don't want to pay your lawyer to watch you read. By familiarizing yourself with the document beforehand, you can identify specific questions and concerns. This allows your lawyer to address your questions directly, saving you time and money. A basic understanding of the document will help you participate more actively in the discussion. You'll be able to ask more specific questions and provide valuable input, leading to more efficient and productive meetings. Reviewing the document in advance can also help you identify potential issues or areas of concern. By addressing these upfront, you can reduce the need for follow-up emails and calls, saving you time and money. A better understanding of the document will also empower you to make informed decisions about your case. This can lead to quicker resolutions and fewer legal fees. Eighth is, don't make your lawyer chase you for information. As I've said several times, lawyers bill by the hour. When they have to spend time chasing you for information or documents, it adds to the overall cost of your case. Respond to requests quickly. Timely communication can help avoid misunderstandings and unnecessary back and forth, which can save you time and money. By promptly responding to requests, you help your lawyer stay organized and on top of your case, which can lead to a quicker resolution. Ninth is to utilize a paralegal or legal assistant when appropriate. For non-legal matters like requesting a document or scheduling a meeting, reach out to a legal assistant or secretary instead of your lawyer. Legal assistants handle administrative tasks such as scheduling appointments, answering simple questions, and providing case updates. You can also request that a paralegal handle certain tasks on your case, such as legal research and document drafting. You would make the request that the paralegal do this type of work when you sign the retainer agreement. By delegating these tasks to paralegals, attorneys can focus on higher-level legal work, such as legal strategy and court appearances. Paralegals typically charge lower hourly rates than attorneys, making them a more affordable option for many legal tasks. Finally, and maybe most importantly, only contact your lawyer for legal advice. We all need to vent sometimes, especially during stressful legal situations like divorce or child custody cases. It's completely natural to want to express your feelings. However, remember that lawyers are not therapists. While your lawyer cares about your situation, their primary job is to provide legal advice and representation. Every minute they spend listening to your frustrations is time they can't dedicate to your case. It's better to use your lawyer's time to discuss strategies, review documents, and prepare for court. To save money and get the emotional support you need, consider talking to a friend, therapist, or spiritual advisor. They can offer emotional support without adding to your legal fees. I hope those tips were helpful and that you'll use them the next time you need to speak to your lawyer. Next, let's discuss the specific circumstances under which a portion of your retainer may or may not be refunded. Typically, if your case ends early, either through a settlement or a court decision, before the entire fee is used, you won't get a refund. The retainer fee you paid will be the total cost for the time spent on your case. If, however, you decide to switch lawyers or represent yourself before your case is over, any unused portion of your retainer fee should be refunded to you. It's important to remember that, although you can fire your lawyer at any time, you may still owe fees for the work they've already completed, any expenses they've incurred on your behalf, and an administrative processing fee to wrap up your case in their office. The administrative processing fee can be quite high. I've seen it as high as $750. Make sure the administrative processing fee is used for transferring your case to your new lawyer or sending you your case file. You shouldn't pay for this twice. When you see your itemized bill, check if there are charges for both transferring your case and an administrative processing fee. If so, question it. You might not need to pay both. The administrative processing fee should cover the costs of transferring your case to your new lawyer or sending your case file. As I mentioned at the beginning of the workshop, retainer fees are typically not enough to cover the entire cost of your case. Once the initial retainer fee is used up, your lawyer will ask you to pay more. Typically, your lawyer will ask you to pay the same amount you initially paid. For example, if your initial retainer was $5,000, you'll be asked to pay another $5,000 for the lawyer to continue working on your case. It's generally hard to predict how long a case will last. For this reason, lawyers sometimes include language in their attorney-client agreements that guarantee a set hourly rate for 1 year, but they usually reserve the right to raise the rate after that year. Make sure there's a limit on how much they can raise rates. For example, no higher than 10% per year and a requirement for your written approval to raise the rate. Another expense to consider is expert witness fees. You might need an expert to prove an important element of your case. For example, a forensic accountant can uncover hidden assets in a divorce, or a child psychologist can assess your child's emotional well being to make recommendations regarding custody arrangements. Expert witnesses can be expensive, and lawyers typically require advance payment of their fees. Your attorney client agreement should require your approval before your lawyer hires an expert witness. This way, you can control costs. Ask your lawyer for the total cost of the expert upfront to avoid any surprises. Next, I'd like to talk about your rights and responsibilities as a client. I won't go into great detail here, but I wanted to make sure you have in your workbook a sample list of your rights and responsibilities as a client. A good retainer agreement clearly outlines the expectations for both you and your attorney. This includes fees, billing practices, how you communicate, and who makes the decisions. By being clear from the start, you can avoid misunderstandings and build a strong relationship with your lawyer. These next two slides just list your client rights and your client responsibilities. There are detailed explanations of each of these points in your workbook. Moving on, we'll discuss now fee disputes and arbitration. Many times, disputes between lawyers and clients about fees are resolved through arbitration, especially when both you and your lawyer agree in your attorney-client agreement to resolve their fee dispute through arbitration. Arbitration is a method of alternative dispute resolution where a neutral third party called an arbitrator makes a binding decision on a dispute between two or more people. Attorneys often prefer arbitration for fee disputes because it's usually faster, less expensive, confidential, and legally binding. This means that once an arbitrator makes a decision on the fees, it can't be challenged in court by you or the attorney. You're both stuck with the decision. An example of a fee dispute would be, for example, a client hires an attorney to represent them in a divorce case. The attorney charges an hourly rate of $350. After several months, the client receives a bill for $20,000. The client believes the bill is excessive, arguing that the attorney spent too much time on certain tasks and that some of the work was unnecessary. In this case, the client may dispute the number of hours billed by the attorney, arguing that the time spent on certain tasks was excessive. The client may believe that the attorney engaged in unnecessary work or overcomplicated the case. The client may also argue that the attorney did not provide detailed invoices or explanations for the billed hours. An arbitrator will weigh the client's concerns against the attorney's justifications for the fees and determine a fair amount the client owes, which could be the full $20,000 or a reduced amount. I know it might seem like the last thing you want to do, but if you ever consider disputing a legal bill, I recommend consulting with an attorney you trust that specializes in legal fee disputes. They can advise you on your rights and the best course of action. For the next few minutes, I want to share some information to help you spot red flags and negotiate a better attorney-client agreement. The first red flag is an unclear scope of representation. As we discussed at the beginning of the workshop, every attorney-client agreement should include a clear and concise scope of representation. This outlines exactly what legal services your attorney will provide. If your agreement doesn't specify the scope of representation, it's important to ask your lawyer to clarify it in writing. A clearly defined scope prevents misunderstanding and unrealistic expectations. You want to make sure both you and your attorney are on the same page about the services being provided and the fees associated with them. The next red flag is sole discretion decision making. Some law firms include a clause in their attorney-client agreements giving them sole discretion in handling your case. Sole discretion means the attorney has complete control over your case, limiting your ability to make decisions about your case. I strongly advise against agreeing to this. When you give your attorney sole discretion, you're essentially giving your attorney the power to make decisions without your input. This can lead to strategies or decisions that may not align with your personal goals or values. You also might not be fully informed about the progress of your case or potential risks. Without your involvement in decision making, there's a greater risk of incurring unexpected costs. For example, the attorney might pursue expensive litigation strategies without your knowledge. If you're unhappy with the outcome of your case or the fees charged, it becomes more difficult to hold the firm accountable for their actions or inactions when you've granted them sole discretion. Next is an unclear fee structure. Your attorney's fee structure, whether it's hourly or a flat rate, should be clearly stated and agreed upon up front. Any additional fees, like court filing fees, expert witness fees, or other expenses over a certain amount, should require your prior approval. You should also know how often you will be billed, whether it's monthly or quarterly, and ask for detailed invoices. This will help you track your expenses and identify any potential overcharges. It's also important to know what payment methods are accepted, such as checks, credit cards, or bank transfers. An unclear fee structure can lead to unexpected and potentially high legal costs. By understanding how fees are calculated and monitored, you can better control your expenses and make informed decisions about your case. Next are excessive fees. If you review your attorney's bill and think the fees are too high, don't hesitate to ask questions. If you're still concerned, consider getting a second opinion from another attorney. Excessive fees may signal a lack of transparency in the attorney's billing practices. While most attorneys are honest, some may overbill by charging for unnecessary work. Excessive fees can sometimes indicate inefficiency on the part of the attorney, meaning they are spending more time on tasks than necessary. Remember, you're in control. If you're unhappy, you can always switch lawyers. Just be aware of any potential fees associated with transferring your case. Next are bill dispute charges. I mentioned earlier that you should not be charged to review and dispute your attorney's bills. A respectable attorney should be willing to address your billing questions and concerns without additional charges. If you find yourself in a situation where you're being charged to review your bill, it's wise to seek legal advice from another attorney to understand your rights and your options. A significant red flag is if you see that there's a one-sided termination provision. Both you and your attorney should have the right to terminate the relationship under reasonable circumstances, and your attorney-client agreement should clearly outline the procedures for termination and the transfer of your case file. You should never assign away your right to fire your lawyer. However, it's important to understand that you'll still be responsible for paying for services already provided, and there may be a fee to transfer your case to a new attorney. Next is the administrative processing fee that I spoke about earlier. As I mentioned, some lawyers charge a high fee when you decide to switch lawyers. If your attorney-client agreement includes an administrative processing fee for terminating the agreement, try to negotiate its removal. At the very least, ask for written confirmation that this fee only applies to transferring your case and that you won't be charged twice for the same process. Next are credit card chargebacks. Most lawyers accept credit cards and electronic bank transfers to make things easier for you, the client. However, it's important to be aware of a common clause in attorney-client agreements. This clause might waive your right to dispute charges, even if you feel you didn't receive the services you paid for or were dissatisfied with the work. This means you could lose the ability to seek a refund or dispute the charges with your bank or credit card company. So, while it's convenient to pay electronically, it's important to read your attorney-client agreement carefully. Understand what you're agreeing to and don't hesitate to ask questions if something isn't clear. If you have concerns about waiving your dispute rights, consider asking to have that provision removed from your agreement. Next are overly broad confidentiality clauses. Your attorney-client agreement will typically include a confidentiality provision to protect your attorney-client privilege, which protects confidential communications between you and your attorney from being disclosed to third parties. However, there might be another confidentiality provision that you should pay close attention to. Some agreements require you to agree not to make any negative or insulting comments about your attorney or their law firm, either online or in person. This could limit your ability to share your experiences, even if they were negative. Before signing, carefully consider whether you want to agree to such a broad confidentiality clause. It's important to balance protecting your privacy with your right to express your opinions. Finally, is if there's a lack of a dispute resolution process. We've talked about how many attorney-client agreements include arbitration clauses. While arbitration can be a quicker and less expensive way to resolve disputes, it's important to be aware of agreements that don't specify any dispute resolution process at all. If your agreement doesn't include an arbitration clause or any other method for resolving disputes, you may be left with the option of filing a lawsuit. While this is a possibility, it can be a long and expensive process. Therefore, it's beneficial to have a clear dispute resolution process outlined in your attorney-client agreement. Whether it's arbitration or another method, knowing how to resolve potential issues can save you time and money in the long run. Before we wrap up today, I want to share my pearls of wisdom when it comes to attorney-client agreements. First, when you meet with an attorney for the initial consultation, request a copy of their retainer agreement to review carefully at your own pace or ask to have it emailed to you. Take your time to read it carefully. Make sure you understand everything and don't hesitate to ask questions. An attorney-client agreement is a legal contract, so it's important to know what you're signing. If you don't follow through on everything you agreed to, there could be serious and expensive consequences. Second, consider getting a second opinion. Consulting with a knowledgeable and experienced attorney like myself can help you identify potential red flags and compare options. You want to make sure you're selecting the right attorney for your needs. Spending a little extra money up front to make sure you're not getting into a bad situation could save you a lot of money down the line. Finally, don't be afraid to negotiate. If there's anything you're uncomfortable with, ask to have it changed. If you'd prefer to pay your fees in installments, ask your attorney if they offer payment plans. Remember, you won't know unless you ask. I can't believe we've reached the end of the workshop. Thank you so much for joining me. I hope the session provided valuable insights and equipped you with the tools to better understand attorney-client agreements and negotiate favorable terms. If you have any questions or need personalized guidance, please don't hesitate to reach out to me. You can find my contact information on the slide and in your workbook. It's been an absolute pleasure helping you understand your rights and options. I hope this workshop made you feel more at ease and in control of your legal journey. Remember, you don't have to figure everything out on your own. There's always help available. Thank you and have a great rest of your day.